Good afternoon, everyone. Welcome. My name is Bill Amato, and I'm the Police Legal Advisor for the Tempe Police Department. So that's a little bit about who I am, where I come from. Today, and dealing with people with mental illness. And I'm not just talking about your legal advisors here. I'm actually talking about the other people with mental illness that you have to deal with in law enforcement. This presentation is going to be a little bit different than some of the other legal officer tracks. I spend a lot of time about the fact because cases really are going to draw more of a big issues in dealing with mentally ill individuals within our community. So let's start with the problem. Right now in the United States, adults are diagnosed with serious mental illness. That's a have drug and or alcohol abuse that go. And last year, 1 in 4 officer-involved shootings, the individual suffered from. Okay, this is going in and out really bad. I think I'm just going to yell. So, stay put. Okay, I'll stay put. There we go. That sounds a little better. So why is that such a big issue? Well, because one of the things that we are seeing is we're seeing a population that is growing exponentially. We're seeing social services that are going down exponentially. And the crisis is coming to law enforcement. Because when other agencies and other departments aren't able to deal with mentally ill individuals, who does the public call? Yeah, they call 911, right? You know, we have criminals and we have people with mental illness. The problem is that in law enforcement, we've always been trained to deal with criminals. And we haven't been trained well enough to deal with individuals with mental illness. So today we're going to talk a little bit about the social implications, you know, the growing population of those with mental illness and the lack of resources out there. And really more importantly than anything else is the police response, right? How do we respond to these individuals? Because how we respond is going to be very important in how our community looks at us, how we can look at ourselves in the mirror after the day is done, and ultimately the liability and the consequences that go with dealing with people with mental illness. Because, you know, not only is that a growing population, but we have, you know, military people coming back with PTSD. We have, you know, the drug and alcohol abuse that's being just proliferated by the legalization of drugs now. So let's talk about it a little bit. Now, I'm going to make a confession to you, okay? You know, this doesn't happen very often. I'm going to say something that I never in my life thought I would ever say. And I never thought I would say it in public in front of a camera. Okay, are you guys ready? You know, those of you who are standing, you might want to sit because this might knock you off your feet. Okay, you ready? The Ninth Circuit might be right. I'm sorry, that physically hurt me to say it, okay? It physically hurt me to say that. But we're going to talk about a lot of cases, and some of these cases go back a while, but really, again, what we're going to do is we're going to draw this picture of where we started and where we've gotten to with case law dealing with mentally ill people, okay? So I try and get it out of your mind, and you know, I know I've completely lost credibility with everyone in the room now that I've said that. So when we talk about force, of course, we always have to go back to the old standby, right? Graham versus Connor. We look at the severity of the crime, whether the person possesses an immediate threat, and whether or not they're actively resisting. Well, that's a great standard when we're dealing with criminals. But what happens when we're not dealing with criminals? You know, then you have to look at the governmental interest weighed against the intrusion, okay? And that really doesn't necessarily draw an accurate account of how to deal with mentally ill individuals. So let's look at some cases that have come up over the last 20 years and kind of see where they started, where they're going, and where ultimately I think they're going to be taking us. So the first one is Quezada versus County of Bernalillo. Basically, very short synopsis of the facts is, police officer sees a car parked behind a warehouse, sees that there's somebody in the car, goes up, there's a woman in the car, she's distraught. She's got a gun, she's waving it around, she's putting it up against her head, she's putting it in her mouth, she's telling them to leave her alone, she just wants to be by herself. He calls for backup, 2 other officers come, they start talking to her. She's like, leave me alone, leave me alone. So they call for a negotiator to come. But before the negotiator comes, one of the officers approaches and gets very close to her and is continuing with his weapon drawn to talk to her. While this is happening, she takes the gun and she's aimlessly, flouting it about within the car, talking about wanting to kill herself. And at one point, she points the weapon towards him. Whether it's intentional or not, we'll never really know. He then takes his gun, fires 3 times into the car, and kills her. Family sues because, well, you know, we live in America and everyone sues. And the district court grants immunity. The appellate court reverses and says, wait a minute, we don't really like that answer. We're going to send it back and we're going to let you take it to a jury. So the trial court awarded $1.24 million to the family originally. The 10th appellate court reversed, remanded for the civil rights violation back, and then ultimately ruled on the negligence claim, failure to train, and on mental health issues. And specifically what the court said in its reasoning was Saucer, who was the deputy, placed himself in great jeopardy by standing in the open and close to Griego's car. Griego was the person, the distraught woman. His vulnerable location left deadly force as the only option. He amplified the risk of harm to Griego, and Deputy Saucer created the danger that led to the use of deadly force. And so the court actually, in this opinion, talked about weapons that officers have that they've never talked about before. And this is the first time we really truly see a court talking about two weapons on an officer's duty belt that had never been mentioned before: time and distance. Okay? And they actually use the term that these are weapons for the officer to use and to take into account when dealing with somebody in this sort of situation. And so what ultimately wound up happening is they looked at the tactics used by the officer and whether or not they used both time and distance to accelerate or de-escalate the situation. And ultimately this went back to the trial court for deliberation, and the plaintiffs were successful. So having said that, the next case is Alexander versus San Francisco, and this is back in 1994. Mr. Alexander, he's a hoarder. He's a 70-year-old man who is obese, almost blind, dealing with mental illness issues, and he has a house that is leaking sewage, hoarding, you know, messes, smells coming out of it, all of those sorts of things, and the neighbors keep calling to complain. Code enforcement goes out there, he won't let them in. Tells them, you know what, leave me alone, leave me alone. He's actually got the front door nailed shut. When they go out there, he tells them, it's my house, leave me alone, you're not allowed in here, you don't have a warrant. So they'll go get a warrant. Now this is not an arrest warrant, this is a warrant to go in and inspect the premises. He won't let them in. So they call the police, who come out to do a tactical approach to the house. Now again, they know what Mr. Quaid is. He's a 70-year-old man who's half blind, somewhat of an invalid, and he's already told everybody that he has a gun and he'll use it if anyone comes into his house. So what do? They force entry into the house. He's at the top of the stairs. He's got a little .22 in his hand. He points it at them and tries to fire. It misfires. They see him pointing the gun. 5 of the 7 officers who are armed shoot him and kill Mr. Quaid. So what do we think? Bad facts make bad case law, right? I mean, these are not good facts. And actually, before they shoot him, he says, I told you I was going to use it. So again, now we're in the Ninth Circuit. What does the Ninth Circuit say about this case? Well, the Ninth Circuit looked at this case and said, well, you know, at the time they pulled the trigger, the officers were probably justified in pulling the trigger, because what happened? They had a gun pointing at them. But the Ninth Circuit said, well, but wait a minute. You can't look at it in a vacuum. And the Ninth Circuit said, we agree with the plaintiff that the fact that the officer's primary purpose in storming the house was to arrest Quaid rather than to assist the health officials in executing the arrest warrant, Quaid's Fourth Amendment rights were violated. Okay? So what does that mean? Basically means that the court is saying that when you're kicking in doors on this type of warrant, you know, you're basically bringing on the consequences of your own actions. So the court went on to say it's important to understand exactly what the plaintiff's claims are. She argues that it was unreasonable for the officers to storm the house of a man they knew to be mentally ill, elderly, half-blind, recluse who had threatened to shoot anybody who entered. And that's what the court's ruling was it wasn't the shooting, it was the entering. And we all heard this morning, for those of you who were in the Supreme Court update, that the Ninth Circuit provocation rule is gone. But this really isn't the provocation rule. This is the proximate cause rule that the Supreme Court has upheld. And so I think that, you know, if this case were to be heard today, we would probably have a similar result. Plaintiff argued that the defendants used excessive force in creating the situation by storming the house. Okay? So, again, it was originally granted qualified immunity, went up on appeal, and the qualified immunity was overturned, and it was sent back. So, now, just to make all of our heads hurt a little bit more for those of us who are attorneys in here, let's talk about the comment that was made by the captain right after the shooting. It wasn't necessarily dangerous, but we could have been waiting all day long. The man was just unresponsive to any of our demands, any of our requests. And with the hostage negotiators and myself, it appeared that he was not going to respond, and we felt that rather than keep traffic blocked up and the streets blocked all day long, we would just try and go in and arrest him. Okay. Now, for those of you who aren't lawyers, all of us lawyers are thinking, okay, how much do we make that check out for now, right? So you can't make this stuff up, folks. You know, you just really can't make this stuff up. So again, we have the Ninth Circuit looking at the difference between somebody who is a criminal and somebody who is merely dealing with mental illness. So next comes Dorley versus Rutherford. This is a case in which Mr. Dorley in California is diagnosed with hepatitis C, gets very distraught over the diagnosis. So rather than taking positive steps towards fixing it, he decides to mix his medicine with vodka. Always a good way to do things. He gets disturbed, gets violent, wife calls 911. When the officers get there, she and the family leave, he's in the house by himself. The officers, the first three that are there, start talking to him. He's distraught, he's verbally abusive, but he's completely compliant. When they say drop something, he drops it. Now he's calling them every name in the book when he's doing it, but he is being compliant when they're talking to him. So they continue to talk to him, and he's, at one point he grabs the porch a little bit and a piece of wood comes off in his hand. Officers are scared it could be a weapon. They tell him to drop it, he drops it. So eventually they keep telling him, they're talking to him, but he won't come off the property, he won't let them in the property. And ultimately what winds up happening is he starts walking towards an officer. And in his hands when he's walking towards the officer, he's got a child's plastic crossbow and a bottle of what they think might be gasoline or lighter fluid. They're not really sure. And he's walking towards this officer, and the officer doesn't say anything, doesn't tell him to drop this stuff, but says, when he got to a certain point, I knew if he got beyond that point, I was going to fire my weapon at him. Now, this weapon was not a gun. It was a beanbag, sage gun, whatever you call it, whatever your agency uses. And so once you cross that line, officer fires the beanbag gun, hits Mr. Dorley in the face, and essentially removes his left eye. So, goes, of course, to trial. The trial court granted qualified immunity, and of course, guess what happens? Court of Appeals overturns it. And when they overturned it, paraphrasing the court, basically what they're telling the court and the police, what they're telling the police department is, don't expect us to hold up summary judgment when you don't differentiate between criminals and people who are suffering with mental illness. Because again, this person had committed no crime. And remember, we talked back about Graham, the severity of the crime. Well, we don't have a crime in these situations. And we're seeing this preponderance of cases, and a lot of them are coming out of the Ninth Circuit, where it really truly is just a civil standby, a disturbing the peace call, things like that, where officers are taking actions that the court is really having a problem with. So, in California, as a result of this, a lot of things have changed. They've done CIT training. They have all kinds of specialized units to deal with this. These are the kinds of things we'll talk about towards the end of the presentation. But pretty early on, California started realizing, hey, the writing is on the wall. The courts are not going to give us qualified immunity in these cases when we're dealing with individuals with mental illness. So next case, so they talk about the reasoning in the Dorley case. And they, again, talk about distraught individual rather than an armed and dangerous criminal. Because we all know that generally, when we're talking about armed and dangerous criminals, the use of force that we have to use is going to be upheld in most places, if not the Ninth Circuit. But when we're talking about somebody who's just emotionally distraught, they say use of force may actually exasperate the situation. Even if the emotionally disturbed person is acting out and inviting officers to use deadly force to subdue them, the governmental interest in using such force is diminished by the fact that officers are confronted not with a criminal, but with a mentally ill person. So again, this goes to that whole topic that we've talked about before in the legal officer section. How many times have we heard officers kicking in doors to save somebody from killing themselves, and what do they wind up doing? Shooting and killing them, right? I think the courts are going, you know what? That doesn't make sense to us. And, I hate to keep harping on this, but when the Ninth Circuit starts making sense, we got to be asking ourselves, what's going on here, folks, right? So, yeah, I know. So let's go to another case. Glenn versus Washington, still in the Ninth Circuit. Mr. Glenn's an 18-year-old, just got dumped by his girlfriend. He's not happy about that. He starts drinking, he starts banging things around the house. His mom calls the 911 to get assistance from the police. When they get there, several officers start staging because they know that he's emotionally distraught. Unfortunately, one officer decides to skip the staging area, and we all know what always happens when an officer skips the staging area, and he proceeds to the house by himself. First person he encounters, he yells at him, "Get on the fucking ground." Excuse my language, but that's what he said, and is yelling at the person to do this. Well, of course, it's not actually Mr. Glenn, it's one of the neighbors, and by the time they get this all resolved, that neighbor goes away, but he tells the officer, "That's Glenn over there." So they take the family away, and it's just Mr. Glenn. They send the family into the house, and Mr. Glenn is outside, and he's talking to him. He's completely confused, completely distraught. He has no concept of what they're saying to him. When the officers yell at him, he's like, "Why are you yelling at me? Why are you, doing this to me?" Because he doesn't understand what's happening. So they continue to talk to him, and another officer arrives on scene, and this officer, who also, of course, skipped the staging area, immediately gives orders, it's a sergeant, to the officer to shoot him with the beanbag gun. They shoot him 6 times with the beanbag gun, and each one of them hits Mr. Glenn, pushing him back towards the house. Well, bad facts, bad case law. Who's in the house but his family? So he keeps getting pushed back by the gun and is getting pushed towards the house. The other officers see him going to the house where they think he may be a danger to the family, and they fire their guns, shooting and killing Mr. Glenn. So, again, we now look to the courts to tell us what we did right, what we did wrong, and what they think we should have done. And here the court says, "We've made it clear that the desire to quickly resolve potential dangerous situation is not the type of governmental interest that justifies the use of force that may cause serious injury. We also recognize in Dorley that when dealing with EDPs who create a disturbance or resisting arrest as opposed to a dangerous criminal, officers typically use less forceful tactics." Okay? So look, we're talking about some very different language than what we were talking about when we started talking about Graham. And they specifically cite Dorley, which is the case that we had just talked about. The facts in this case, viewed in light most favorable to the plaintiff, bear out Lucas did not respond positively to the officer's forceful tactics, and just before officers fired the beanbag gun, Lucas pled, "Tell them to stop screaming at me, and why are you yelling?" Okay, so again, the court is starting to look at things that have nothing to do with Graham, right? I mean, did we see any of this language in Graham? No. So the family hired a subject matter expert in this trial, and that subject matter expert was a former chief of police. Pretty good expert to have if you're a plaintiff in a case like this. And the chief talked about what should have happened and the tactics that should have been used. And the court in this case clearly expected a differentiated level of response from police officers because we were dealing with somebody that was emotionally disturbed and not with somebody who had committed criminal acts. And they said summary judgment is not going to be automatic in these cases. And they have repeatedly said that because they want to, at least from my reading of these cases, they're trying to give us the heads up. Hey folks, the train is coming. We are not going to just automatically grant summary judgment in these cases. And so the expert, the chief of police expert, talked about some of the tactics that should have been used. Slowing it down. Don't increase the subject's level of anxiety or excitement. Attempt to develop a rapport, and time is on the side of the police. Now, I think a lot of us look at that and go, yeah, that all makes sense. But are we necessarily training our folks to do those sorts of things? So, again, towards the end, we'll talk about, what we should be doing as a result of these cases. But once again, we have a court talking to us about, hey, wait a minute. We're talking about an 18-year-old kid who's distraught over losing his girlfriend. We're not talking about a murderer or a rapist or an armed robber. And so the court, again, is distinguishing and saying, time out, folks. You got to be looking at this with a different set of glasses on. Next case is Hayes versus County of San Diego. Mr. Hayes was, again, emotionally disturbed. He had tried to commit suicide a couple of months ago, unsuccessfully. Tried again on this particular day. Went out to the garage, turned on his car, had the exhaust fumes going into the garage. The door was shut and locked. His wife comes home, opens the door, gets him out. He's okay. They go into the house, and he's in the house on the sofa, still wanting to kill himself. So she calls the police, and the police come out. Now, again, if we notice in all of these cases, are we calling mental health experts? Are we calling the people who are trained in this area of expertise? No, we're always calling the police. And that's because in most society, most of our agencies, most of our jurisdictions, there aren't the resources that are necessary, and so it's going to fall to police. So the two deputies get there, Deputy King and Deputy Greer, and they walk into the room. And he's like, leave me alone, I just want to die. And they're like, please, get up, stand up, please. He stands up and his hands are behind his back. They tell him to take his hands out from behind his back. Well, when he does, he's got a knife in his hand. And the knife in his hand basically is held like this, and they're like, put the knife down. And he starts, and one says, put the knife down, the other one says, come towards us. He starts coming towards them. The one who says, put the knife down, thinking that his command was put the knife down, fires, shoots, and kills Mr. Hayes. Again, was there a danger potentially there? Probably so. But are we talking about a criminal, or are we talking about somebody with an emotional issue that's going on? So in this case, again, Ninth Circuit, so we're talking about what is the court going to tell us about this? This court goes further than any of the previous courts and talks about the totality of the circumstances, now includes what actions officers may have taken before a deadly encounter. Because let's not forget, 4 months earlier, he had tried to commit suicide. These officers did not know that. Dispatch did, but the officers did not. And the court actually went as far as saying these officers did not avail themselves to all of the information that was otherwise available to them. And they asked these questions. Now, of course, the court, so they didn't answer the questions, but they asked these questions. How many times had Hayes previously attempted suicide? Was he armed? Was there a case manager? What other resources were available to the deputies? And these are questions that the court actually put in their opinion. Now, again, like I said, they never answered any of these questions, but they're now starting to expect us to ask these questions of ourselves. What do we know? How are we walking into these situations? What have we done as far as the ability to educate ourselves so that we don't walk into these situations and have ourselves set up to have something go sideways like this? So in this case, again, qualified immunity was overturned, and the case ultimately wound up settling for an undisclosed amount. Okay, so now we're going to move forward to Roel versus Hamilton County. Okay, this is another emotionally disturbed person situation. He suffered from socioaffective disorder, and paranoid delusions, and he stopped taking his medication. And unfortunately for him, his wife was out of town when this happened. So he winds up entering into a state of excited delirium. He's ripping at his clothes, he's tearing off his clothes, he can't cool off. He's in his backyard, it's like a condominium complex, and he's grabbing the hose and he's trying to soak himself down. He grabs a potted plant and throws it through his neighbor's window and actually goes into the neighbor's yard while all this is happening. Neighbor has no idea what's going on. They call the police. Police arrive. And it's very clear to the officers who arrive on scene that he is experiencing excited delirium. And he's got another potted plant in his hand, and he's got the hose in his hand. And he is, wildly, swinging things around, not in an aggressive manner, but just in a frantic manner. And at one point, he's like swinging the hose almost like a lasso, I guess, for lack of a better term. And the officers are trying to tell him, whoa, 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 slow down, stop. They're trying to calm him down, but they can't. So eventually what they wind up doing is after they've warned him, they tase him. And the first time it didn't work, and then they tase him multiple times, but it didn't really have the effect on him that they needed. Eventually they get him handcuffed, and he's still thrashing, so they do leg shackles. He's positioned on his side, and once he's secure, it sounds like he's snoring. Well, we all know what that means. He stopped breathing. They tried to resuscitate him, and at the hospital he's pronounced dead. Now, what's interesting about Roel is that they go forward on both a 1983 claim and an ADA claim. And this is one of the first places we start seeing ADA pop its ugly head into the discussion of dealing with people with serious mental illness. So under the 1983 claim, the court said diminished capacity of an unarmed detainee must be taken into account when when assessing the amount of force exerted. But Roel's excited delirium did not, preclude the deputies from using a reasonable amount of force. And in this case, they said using of the taser was a reasonable amount of force. So on the 1983 claim, they were granted qualified immunity. But again, what they did was they were looking at it from the Fourth Amendment and the Title II of the ADA. And so under the ADA, they looked at it and said, okay, what accommodations are being made? Because when you look at ADA and how it works for mentally disturbed individuals, you're really looking at two questions. One is, was there a wrongful arrest? And the other is, was there a wrongful arrest for some liability purposes? Or did we fail to accommodate the ADA symptom? So in this case, the police officers were granted qualified immunity, and so was the department. And the ADA claim actually was dismissed as well. But again, like I said, this is the first place where we see ADA come up, and we were granted qualified immunity in this case. The law enforcement was. Now we go to Young versus Sunbury Police Department. Mr. Young is an 18-year-old who suffers from several physical and mental disabilities, seizures, Asperger's, mild mental retardation, ADHD, developmental delay, a laundry list of maladies. And he was at the library because he was getting private tutoring because he couldn't attend regular school. Well, he started having a seizure, and during the seizure, because of the combination of maladies that he was actually trying to rip off his clothes. And so the police were called, and when they arrived on scene, they thought this was somebody that was basically just trying to expose themselves. They didn't necessarily immediately recognize this as somebody who was going through both a physical and mental breakdown. But one of the officers, the second officer who was on scene, knew this child and knew of these maladies as well. And so what wound up happening was they finally got him calmed down, and they arrested him. They took him down to jail, where he spent about the next 24 hours before his dad could bail him out. And again, so what winds up happening, we all live in America, they sued. And they sued under the ADA, again, in this case, saying, wait a minute, this was a disability. You knew my son had a disability, and you did not take the appropriate accommodations, nor did you take it into account, and therefore it was a wrongful arrest. And so the court looked at it and said, okay, let's kind of look at this. The arrestee was a qualified individual with a disability. That was clearly the case. He was wrongfully arrested because of misperception about his disability. He wasn't trying to expose himself, he was just ripping at his clothing. And the police failed to reasonably accommodate his disability in the course of the arrest, by the mere fact that they did arrest him, and that they did have him sit in a jail for 24 hours. And that the officers acted with deliberate indifference. And where the deliberate indifference comes from is the second officer who arrived on scene who knew about the disabilities. Because I think had it just been that first officer, I think we would have been looking at a very different situation here. But it was that second officer that knew about the disabilities and knew the family and didn't do anything about the knowledge that he had, imparted to the other officers to ensure that something like this didn't happen. As the court held, police officers were deliberately indifferent to this serious medical needs and held in favor of the plaintiffs in this case. So, now we come to City and County of San Francisco versus Sheehan. This is the one we've all heard about, went all the way up to the Supreme Court. And again, this was a case that, we all went, oh, okay, easy case, until they brought up the ADA. And we're like, oh, ADA, that's interesting. So again, briefly on the facts. Sheehan is in a group home. She's having a mental breakdown. They want to do a commitment order for her. So they call the officers because she won't come out of her room. Her room is on the second story of the house. There is one entrance to that room and then a window with no fire escape, so it's basically one entrance in and out. The officers arrive, and they're told by the caseworker she's in that room. They go into the room with the caseworker. She's there. She's got a knife. She says, I don't want to go to the hospital. You can't make me go to the hospital. Get away from me, or I'm going to hurt you with the knife. The officers do a brilliant thing. They're like, thank you very much. They step out of the house, out of the room, and shut the door. And they call for backup. Life's great, right? Life's wonderful. It's fantastic. Except, of course, that we wouldn't be talking about this case if that's where the story ended. For some unknown reason, the officers, before the negotiator gets there, before any of the other backup get there, they open the door, back up, and go in with their guns drawn. She comes at them with a knife, and they shoot her. So, of course, once again, we talk about liability. We talk about whether or not she's going to sue us, which, of course, she does. And when she sues under both a 1983 claim and an ADA claim. And so we were all really excited because, especially when this case went up to the Supreme Court, we're like, woohoo, we're going to get an answer to this ADA issue. Because I got to tell you, none of us really had it on our radar before these cases in 2016 and 2017 came up. All of a sudden, it's like this big thing. It's going to the Supreme Court, highest court in the land. We're going to get some answers. We're loving it, right? So the allegations were that the officers failed to provide a reasonable accommodation by failing to account for her mental illness, should have respected her comfort zone, which was the room, engaged in non-threatening communications rather than going back in and confronting her, and used the passage of time to diffuse the situation other than perpetuate a deadly confrontation. Because again, the court said when they stepped out of the room, it was exactly the right thing to do. When they stepped back in the room, we obviously have some serious concerns. So again, sound familiar? It's exactly what we've talked about in Glenn and Dorley and some of those other cases. So the Ninth Circuit, we all know where they're going to go, right? They're going to deny qualified immunity, and they're going to send it back for trial. Well, it gets appealed up to the Supreme Court, and the Supreme Court granted the qualified immunity on the 1983 claim. Okay, so a little bit of a win for law enforcement. And like judges and only judges can do, they completely sidestepped the ADA question. They did not address it at all, and so we're still stuck today with this, okay, what does the ADA mean for us? What does it mean for law enforcement when we're dealing with somebody with mental illness? And they gave us absolutely no clue what they think we should be doing when it comes to ADA accommodations. So, what does the ADA mean? Well, the ADA covers essentially all of the activities law enforcement regularly engages in. Receiving citizen complaints, interrogating witnesses, arresting, booking, holding suspects, 911 emergency centers, providing medical services, enforcing laws while providing reasonable accommodation. Well, what is reasonable accommodation? And what kind of accommodation do we make during arrests? Especially arrests of individuals that have mental illness. All questions that I think are unresolved. And any questions that are unresolved typically do not bode well for law enforcement when we have to deal with things. So, we get qualified immunity in Sheehan. But I always, and to me it's always interesting when people go, woohoo, we won, we got qualified immunity. Because qualified immunity can be a victory. But it may not be the victory that we all think it is. Especially like, and I don't mean to pick on anyone in particular, but some of the police magazines, they'll put articles out, oh, this officer was granted, qualified immunity. It's a big win for law enforcement. Well, folks, I got to tell you, qualified immunity is not always a big win for law enforcement. Because coming up in the, and we'll talk about it in the next case, qualified immunity means either that you didn't violate someone's constitutional rights, or you did, but it wasn't clearly established. Well, guess what, folks? If you violated someone's rights, and the court says, but before today it wasn't clearly established, what did they do when they said that? They just made it clearly established. So sometimes qualified immunity is a win for that officer, but may be a loss for the rest of the law enforcement community. And a great example of that is the next case, Pinehurst versus Armstrong. So Armstrong's bipolar, schizophrenic, and he started to poke holes in his leg to let the air out. Don't know what it means, but that's what he said he was doing. So he's at the hospital, and he flees while the doctor calls the police and is trying to do an involuntary commitment order. So the officers respond, they get there, he's outside, he's running in and out of traffic, he's weaving around, they try and calm him down, they actually get him to come over out of traffic, and he basically sits down on the grass and wraps his arm around a stop sign. And they're like, okay, you need to go. And so they grab him, and they pull him, and they tug, and the inevitable tug of war. Well, I guess Mr. Armstrong's pretty strong, because at one point there are 4 people pulling on him, and they can't get him off of the stop sign. So eventually they get the involuntary commitment papers complete, and they surround Armstrong again, and they continue to try and pull him off, and they can't get him off. So they go to the drive stun with the taser, and he's tased 5 times in a 2-minute period. He finally, releases the pole, they roll him to his side, and he's put in handcuffs and ankle shackles. He's face down as they're doing all of this stuff. When they roll him over, his sister notices that he's blue, his lips are blue, and he's not breathing. So, again, what winds up happening here is he winds up dying as a result of this. Now, in this case, the court said the use of force on Armstrong was unreasonable and disproportionate. He wasn't committing a crime. He wasn't really even a danger to himself at this point. I mean, he had his arms wrapped around a stop sign. I mean, he wasn't out in traffic anymore. And they started to talk about the Graham factors, the severity of the crime. Well, we have no crime. whether or not he was a danger to others. Well, again, arms wrapped around the pole. So in this case, they grant qualified immunity because they said, you know what, although we're saying it was unreasonable force, it wasn't clearly established case law, okay? So do we think that's a win for law enforcement? Come on, you got to remember back like 12 whole seconds ago when I told you it's not always the case. Because guess what? It's now clearly established as a result of Pinehurst, okay? Because even though in this case they said that that was too much force given what the officers were experiencing right then and there, guess what? They said, we're going to give this officer, or these officers I should say, qualified immunity because they didn't know better. But guess what? Now that we've all gone to this presentation, we all know better, folks. And so it's going to be clearly established law. Now, here's how interesting this area of case law is. This is Fourth Circuit, okay? The Fourth Circuit actually cited the Ninth Circuit, okay? Now, the lawyers in this room are like, wow, because we all know citing the Ninth Circuit is almost a guarantee to be overturned by the Supreme Court. So no circuit ever likes to cite the Ninth Circuit. But they did, and they cited several of the Ninth Circuit cases that I've talked to you about because I think the Fourth Circuit saw the same kinds of issues that the Ninth Circuit is seeing when it came to how police officers are dealing with individuals with mental illness. So kind of trying to bring the presentation back around to where we started, imagine what the faces of the Fourth Circuit justices look like when they cited the Ninth Circuit. I got to think it goes right back to that slide that we had earlier, right? That's what the Fourth Circuit judges look like when they cited the Ninth Circuit. So in Pinehurst, though, they talked about, the Graham factors. But Graham factors, the severity of the crime, the resisting arrest, the danger to themselves or to others. So I pulled this cartoon up because I thought it was kind of appropriate. Trying to use the Graham factors, the factors that were given to us by the court in Graham, when you're dealing with a mentally ill person, is, for those of you who are baseball fans, is like stepping into the batter's box with 2 strikes already against you. Because we don't have a crime, and quite often we don't even have, a resisting arrest. So, you've already failed the first 2 prongs of the Graham test. Yeah, I got to tell you, I was never a great baseball player, but I sure as heck would have been a much worse one if I started walking into the batter's box with 2 strikes already against me. So let's take one more case, and then we're going to kind of bring them all back together again. And this is the Corey Hill versus Miracle case. And this one's not a mental illness case, but I think it could be a really useful case, and I'm hoping one that we're going to hear a lot about in the next year or two. In this case, paramedics were called to assist Corey Hill, who was a diabetic who had low blood sugar. I think his blood sugar count was 34, which is really, really low. Deputy Miracle was called along with EMS, and they arrived, and during the encounter, what they're trying to do is they were trying to get an IV into him so that they could save his life. He was extremely combative. He ripped the IV out of his arm, spraying blood everywhere. He was punching, he was pushing. He would not let these people help him live, essentially. Deputy Miracle deployed his taser, drive stun, and to the right thigh, and it calmed him down. They got him calm enough to where they got an IV in, and they ultimately were able to save his life, okay? So again, I know this isn't mental illness, but guess what? The court, in this case, did something really interesting. They're like, why would we use Graham in this case, right? Why would we talk about the Graham factors in this case? Because Graham really doesn't apply because we've got no crime, we have no criminal. Graham was always predicated on the fact that, this was officers' use of force when it comes to dealing with criminals and the ability to use force. So they came up with their own little test here. Was the person experiencing a medical emergency that rendered him incapable of making a rational decision under circumstances that posed an immediate threat of serious harm to himself or others? Was some degree of force reasonably necessary to ameliorate the imminent threat? And was the force used more than was the force used more than reasonably necessary under the circumstances? So they essentially created their own test for medical emergencies. What do we think? You like it? I do. I think the same test could probably be used for mental illness, right? I'd much rather have to face these questions than the question of, well, what crime did he commit? And why was he, how was he resisting arrest if you didn't even have justification for arresting him? And in this case, the court went on to say, if the answer to the first 2 questions is yes, and even if the answer to the third one is no, there's still going to be qualified immunity for the officers in these cases. So again, this isn't a mental illness case, it's a medical case, but I love the fact that we have a court, although not my district, but a court thinking about what may be a more appropriate test for looking at least in this case, medical situations, medical emergencies, and maybe, excuse me, fingers crossed, some other court may take a look at this and go, hey, this would be a great test for mental illness situations as well. So let's talk about it. A lot of people, everyone in here knows Graham, right? We have all, been raised with Graham. We know the standards. Severity of the crime, poses an immediate threat, actively resisting. And then for the last several years, the Ninth Circuit, everyone's been talking about, well, is there a Graham plus standard? Because we know that we're not really applying Graham to the mental illness cases. So there was this phrase that I hated as a lawyer, especially, Graham plus. Where they talked about the Graham standards, they talked about reasonable and proportionate, but then they started, adding other additional requirements to law enforcement, and it got, nicknamed Graham Plus. Got to tell you, I don't like Graham Plus. I mean, as a lawyer, we always, Graham's great. It's, it's hard and fast. It's case law. It's been around forever. And I will tell you, I love Graham for use of force when we're dealing with criminals. I'm not a fan of Graham for dealing with mental illness situations. And now what we're talking about is maybe a new standard is what we need to have. Whether it's what we get out of Corey versus Miracle, where we start talking about the actual situation of somebody who is in mental or medical distress and was force necessary to actually help them. And was that force reasonable? So, I'm not going to tell you, what your district, what your circuit does or what they don't do. What I'm telling you is, you have to understand that, there's people out there that believe Graham's the right answer. People out there that think Graham Plus is the right answer. People out there like myself that's hoping that we're going to get a better answer than what either of those provide to us right now. No matter what district you're in, no matter what resolution you want to see or you think you're going to see, the bottom line is this is an area of law for not only law enforcement, for those of us who represent law enforcement, that scares the you-know-what out of me. Okay? Because I think this is one of the most important areas for law enforcement right now in our country because of the amount of individuals that we have to deal with mental illness. So what do we need to do? We need to get better at dealing with people with mental illness. How do we do that? Okay? Number one, training, right? You may have CIT, you may have mental health training, whatever you call it. We need to get our officers to understand the difference between criminals and people in emotional distress. And when I say our people, I'm not talking just about our officers. Dispatchers need to ask the right questions to arm our officers with the right information before they get there. Detention officers and prison officers have to understand what mental illness looks like in individuals who are in custody. And then obviously our officers, our deputies, whatever we call, the officers that we have out on the street, to recognize, mental illness. Because the bottom line is, if you have somebody who committed an armed robbery and they're bipolar, okay, they're still a criminal, right? Graham applies, they're bad guys, we're going to use the amount of force that is necessary and reasonable. But, often our officers are faced with the guy who's running down the street naked, okay? Now, in Arizona, that's a crime, that's public sexual indecency. But do we really think that the crime is the primary factor here, or is it the mental illness? And so what we have to understand is, and we have to train our officers to do, is to understand the distinctions between criminals and those who are suffering mental illness or emotionally distraught individuals. And where that starts, like I said, is not only with the training, but policies. And again, legal officer section, big surprise, we talk about policies. We have to have the right policies in place to give our officers direction. And we need to keep those policies up to date. We need to have practices, because guess what? Policies are great, but policies can't address every issue, and they can't necessarily address every kind of circumstance that comes up. And here's where I'll fall on the sword, and I'll tell you a story from Tempe. When I first got to Tempe, this has always been an interest of mine, and I'm trying to actually get a full squad, dedicated to nothing but dealing with mental illness in Tempe. But a couple years ago, we had a case where we had a young man. He was 19 years old, and he was autistic. He was also 6'6" and about 260 pounds. And he was going through an emotionally disturbing moment where he was basically banging walls, putting his fist through walls, scaring his parents. And so the parents called Tempe PD. And I have a radio in my office and I'm listening, and I hear all the calls that are coming through. So this kid who's autistic is doing all of these things, and we respond out there. And I'm like, well, that's kind of weird. So I actually talked to the individuals that wound up going out there after everything was said and done. And I came to find out that when we got this call, because it was domestic violence, because he lived at home with his parents, we rolled out there code 3. Okay? I'm assuming, if you don't know what code 3 is, that's bat out of hell fast, lights, and siren. Okay? Now, you may not all be psychological experts or trained in psychology or psychiatry, but one of the things I'm guessing we probably all know is that autistic individuals hate loud noises and bright lights. And that's exactly how we responded to the scene. Bat out of hell fast, lights and sirens on. And I'm like, and I can't blame my officer. I mean, there's nothing in my policy at that point that prohibited him from doing that. That's what they know. That's what I'm telling you. I mean, I'm not pointing fingers at any individual or any agency, but we need to learn and we need to educate ourselves based on, what we're seeing, call it a prediction, a premonition, looking into my, little glass ball up here of where things are going. But I'm telling you folks, I think that where I see things going for law enforcement is that we are going to be under greater scrutiny in how we deal with individuals with mental illness. And that scrutiny is only going to be overcome by having training and policies and procedures and having a true commitment from the agency, not just throwing a policy out there or throwing some training out there and telling our officers to go do it. It's got to come from the top to make sure that our officers understand the commitment from the agency that this is something that really needs to be addressed within our organizations. So again, not only policies, but you're going to look to your practices. CIT, crisis intervention training. We're not going to make our officers, rolling psychologists, but we can have them educated to at least be able to identify certain types of emergencies, mental illness emergencies, excited delirium, those sorts of things. If you have CIT in your state, I highly recommend that you get a strong portion of your agency trained in that area, because it is critical. Because I can tell you, if and when you have a use of force against somebody who's mentally ill, one of the first questions that's going to be asked, we all know, failure to train, failure to supervise, or some of the favorite claims that are made against us, what kind of training did you provide your officers when it came to dealing with mentally ill individuals? De-escalation. I got to tell you, it hurts to say it, but the Ninth Circuit wasn't wrong. I can't go quite as far as saying they were right, but they weren't wrong when they talk about time and distance. And I'll even add, in one of the other cases, talked about cover as being tools on our tool belts. How many of us talk to our officers? We train them on their guns. We train them on their batons. We train them on their OC spray and all that other stuff. I think we need to start talking about those other 2 or 3 weapons that are on their belt that we haven't talked to them about. Time, distance, and cover. Because you know what? The courts are aghast at, we had to go in, we had to speed things up for whatever reason, and we wind up taking someone's life as a result of it. Because I can tell you, I wish I was this good with, sporting events on my predictions, but if you're going to court and your defense is, well, we ran out of time, so we, kicked in the door and killed the guy who was going to kill himself but was not a danger to anyone else, I don't want to be representing you in that case, because it is not going to be pretty, okay? We need to understand that de-escalation, it's the catchphrase for this year, but I think it's the catchphrase for this year for a reason, because we need to understand that, sometimes time is on our side. Sometimes taking a step back is on our side. Now again, if someone's coming at you with a knife, if somebody is truly a danger to you, all bets are off. We're going to go back to the gram factors and, what we should do in that situation. But, you've got somebody in a room that can't get out, or their arms wrapped around a pole and they're not going anywhere and they're not hurting anybody. I'm telling you, if your defense is, well, it was just time to call this and end this because we were running out of time or we didn't want to block traffic, it's not going to fly very well with, I got to tell you, not just the Ninth Circuit. I think this is going to start permeating into other circuits as well. So, what are we talking about here? Well, ultimately, if for those of you who aren't chiefs in here and you go back and you're going to make some pitches to your chief's going to talk about costs. How much is it going to cost to do this? What are the costs of doing it versus not doing it? Well, let's talk about those costs, because I think they're really important to talk about. I think, like I said, predictions, if you kill somebody with mental illness and, it's done because of time or lack of training or something like that, I think you're going to pay a lot of money on the settlement, or if a jury gets it. Public relations. This is, a public relations nightmare. somebody who's either unarmed or if they're armed are not a criminal. Because say what you will, and we've talked a lot about the media and perception and public perception, but individuals who are not criminals are going to get more sympathy than criminals. I mean, I don't think I'm telling you anything that you don't know. And again, if we haven't done everything that we can do to protect these people, and sometimes it even means protecting them from themselves, then it's going to be a public relations nightmare. And then emotionally, I can tell you, I've seen officers who have had to kill emotionally disturbed persons, and it has torn them up. 2 of my officers are no longer on the force as a result of this. It completely destroyed their ability to ever do the job again. So, again, what you're talking about is you're talking about the emotional cost to the officers that are in this situation that have to deal with these kinds of situations. So, what are we learning? Well, hopefully we're learning, right? That's what we want to do. Now, I don't mean to insult anybody, but let's look at SWAT and hostage negotiations and our tactical folks. They all have this group called NTOA, National Tactical Officers Association. And I got to tell you, I'm a lawyer and I work for a police department, but I've never been an officer. So, of course, one of the things I love to do is make fun of my police officers, right? That's what we do. So I always call my SWAT team like the knuckle draggers and, kind of have, running jokes. But NTOA, I got to give them credit, This last year, or actually 2 years ago, they changed their guidelines. And they made, to me, and it's funny because I don't think they really pushed it as a huge change in their guidelines. To me, it was night and day, one of the biggest changes I've ever seen. And that is, they came up with this distinction between barricaded suspect and barricaded subject. Okay? Think about it. Barricaded suspect, criminal. Barricaded subject, somebody who's barricaded but not a criminal. And to me, that distinction is huge and fantastic and wonderful. And so, like I said, if the knuckle draggers can come around to this way of thinking, shouldn't the rest of us be able to do that as well? So I'm sure I'm going to get grief from those of you who are on SWAT out there, but that's okay. It's what I do. So what I implore you to do is think about these things. This was a presentation, like I said, it wasn't real heavy on case law. All of the cases I put up there, I went through very, very quickly, but every site is on there. So if you want to pull those cases up and use them for yourself, the case law or the sites are right on the PowerPoint, which is in your material. So, feel free to use anything that I put out for yourself. But what I'm hoping is that as an organization, as a group, not just Tempe PD or Arizona, but as law enforcement in general, we learn from our mistakes. We learn from, what the court is trying to teach us. Because I think the Ninth Circuit really has put forth what they are seeing as the issues. And if we don't recognize those issues and do something to address them, I think we're going to be in a lot of trouble. So my last point to you all is take this information, do with it what you will, but make sure that you at least talk to the people within your organizations about what are we doing, how are we doing it, are we comfortable with our policies, are we comfortable with the amount of training we get on this, are we comfortable with, do we have a squad that handles these situations, our negotiators, how accessible are they? These are the questions we need to be asking ourselves because day in and day out, I got to tell you, I teach all over the country, and every agency I ever teach at, I ask this question. How many of you are dealing with more mental illness calls today than you were a year ago, and more than 2 years ago, and 5 years ago? Trend is like this, and I don't see it going anywhere but up. So the more we have to deal with this, the more important it becomes that we do it the right way, the way law enforcement should always do it, the right professional way. So I hope that you found this to be helpful and maybe took something out of this that will benefit you and your organization. If you have any questions, I'll stay up here to answer them. Or if you have questions that you want to share with the crowd, that we've got, I think 2 minutes left to go. Okay. Well, thank you very much.